Kindly go ahead.
On behalf of Judy Koech, the applicant in this matter, Your Honor, we file our application dated the 10th of December 2025. The Honorable Court gave directions on the 11th day, December 2025. The office of the ODPP was served immediately on that day, and that duly stamped copy has been attached to the affidavit of service. So the ODPP was served, save that my brother either was not given that application due to the bureaucracy of the Office of the Director of Public Prosecution. You know, the gist of the matter is that the applicant is a principal land registrar. The state got a search warrant and went to our house and took government title deeds and tools of trade. We have annexed an inventory showing the number of title deeds in the custody of the police. As a land registrar, these are documents for her to process to beat the deadlines under the charter of the Ministry of Lands. The owners, some of them who might be here, have no title deeds. And she has no explanation to offer. Equally, they took her personal documents that has completely shattered her to operate as a citizen of this country. Your Honor, the previous miscellaneous applications were closed. And because they were closed, the state failed to charge whoever they suspected.
The miscellaneous.
The miscellaneous, all of them were closed. Your Honor, the police under the CPC and their standing orders can do investigation by summoning suspects. Instead, they opted for a court-assisted investigation. And that is why they filed miscellaneous applications. The court granted them enough days to conclude their investigations. And that is why the court closed those files. Any form of investigation outside the court-assisted investigation can only proceed if one has been charged. Any material recovered was to be brought before this court with an explanation that it is going to form exhibits once a charge sheet has been approved by the ODPP. Your Honor, that is the basis of my application, that we do not need the investigating officer to respond, because there's nothing to respond before you. Your Honor, the applicant has been arrested severally and never arraigned before any court of law. It is our prayer that whatever is in the custody of the police, they have an inventory, it should be released as and when they will think to arrest and charge. My client is not immune to criminal charges. Then lastly, my client is a senior court officer, an advocate of this court, a land registrar. There are directions, very clear directions to the DCI, that only the DPP himself shall approve the charges of a land registrar. That is because of the sensitivity of this matter. You are now equally as an advocate of this court, I made a serious presentation here that protection against land registrars should equally be given to advocates of the High Court. And the Law Society of Kenya is indicted in the way advocates are being arrested and charged. As we pursue that one, Your Honor, it is my prayer that this court protects court officers as much as the court pleaded to the Law Society of Kenya to protect the bench. It should be across board. Your Honor, may you protect this young advocate, this professional, so that she gets her tools of trade. It seems the DCI does not know that people work from home. Next time they will arrest judicial officers who have files to write judgments from their home. And they say these are documents of government that are not supposed to be in private residence. May the court get favor.
Is there any judicial officer who does not have files at home?
The DCI might not be knowing.
I think half of our houses have study rooms because we have these files. We can't work from.
That is exactly the position I'm saying.
We can't.
The land registrar nowadays, they work virtually. Advocates work virtually. We have files of people at home. But the DCI seems still to be in the old bureaucracy. And we do hearings from home. Courts are at home. May the court grant my application before Mr. Ndegwa can also put one word.
I want to associate myself with the submissions made. And most importantly, buttress the fact about the protection of the whole spectrum of administration of justice. When Mr. Omari addresses you to protect an advocate, he's not asking you to protect an individual or to immunize an individual. He's inviting you to protect and immunize the whole process of administration of justice, where an advocate becomes a fundamental instrument of conveying that process of access to justice under Article 48. That is mean, therefore, Your Honor, when an order of such is issued, such warrant is issued by this court against an advocate, the order must appreciate the nature of the business that individual engages in. That advocate engages in the business of administration of justice. You know, in respect to Jailin Mahena, who is an advocate of the High Court of Kenya, an officer of this court, when you granted your orders, Your Honor, the DCI pounced on her in her office, confiscated all the files in that office, all the client's files, which were not subject of the warrant. But more to that, Your Honor, is the question of the confidentiality of the process and the business in which we engage in. That as we speak, Your Honor, that confidentiality has been breached. And it's a sacrosanct protection. It's so sacred that you cannot just breach that confidentiality because it goes to the core of our practice. The majority of the files that were confiscated and carted away by the DCI, they have no relevance in this case. They are still keeping them to date. Where does that leave the entire doctrine of confidentiality? Number two, the question of access to justice, which is a fundamental right as well. That an advocate is not seized of her client's files. They are in the custody of a third party, disguised as investigation. When they made the return of warrants before you, under section 119 of the CPC, they never disclosed this to you. That they have completely grounded the works of an advocate by confiscating her files. in my understanding, and I may be wrong, under section 118, is that a warrant must be particularized. That is, the investigator must know what he or she wants, where it is, and who is in custody of those. So as to, Your Honor, to guard the aspect of an investigator being on a fishing expedition. So, Your Honor, as we speak and as we address you, we want you to pronounce yourself on the question of the confidentiality of those files and whether the same has been breached. And if the same has been breached, what is the import of that breach vis-a-vis the case of Philomena Mwilo? Evidence that has criminally been procured or unlawfully procured. What is the fate? This court has jurisdiction and capacity to make that determination at this inception stage. Because confidentiality is a legal doctrine. It is codified in the Advocates Act. Number two, Your Honor, the question therefore I also want to pose the court is, can this court just issue orders in vain? The last time you were before, Your Honor, you ordered that a motor vehicle belonging to a client to Jailene's client be released. To date, it has not been released. That motor vehicle did not form any subject of the investigation. It was nowhere in your warrants. Even property belonging to clients, they are being confiscated in disguise of execution of an order. That day, when Jailene was, the orders were being executed, she was being ferried by that motor vehicle. She was in her client's motor vehicle. It was equally confiscated. They have refused and declined to release that motor vehicle to the client. You know, finally, the question of confiscation of the money, 500,000 shillings, was equally confiscated belonging to Francis. What is the nexus between an act of forgery and the confiscation of the amounts? What is the nexus? I think forgery is you're putting on either you are making a document, signing it or something, or anything. What's the nexus between the confiscation of that money and the offense being investigated? You know, we urge you to kindly pronounce yourself on those issues. They are fundamental because it goes to the root, to the question of the administration of justice. Number two, they go to the question of whether the court can entertain a fraudulent or fraudulently procured evidence, which has already been determined by the High Court anyway, for that matter, Your Honor. Finally, Your Honor, if you may find it convenient, the IO may be summoned to come and explain to the court the reason why they are still in possession of that motor vehicle.
Is it in this file?
Yes, yes, Your Honor.
Okay.
Yes, Your Honor. The unfortunate thing, Your Honor, we are facing is that the file was closed when these preliminary issues are ongoing, but it's within your custody, Your Honor. There's no much problem or challenge about that. So, you know, we seek your indulgence on that particular issue, and especially the issue of the confidentiality of the evidence, of the files, and the propriety of that evidence. We are most obliged.
My name is Isack. I also mirror the same sentiments by my seniors. The file before you for 170 was closed before some preliminary issues were determined.
How many days were given in that file?
They had been given 10 initially.
Was it closed before the 10 days?
After the 10 days.
So it was closed in time?
Yes, yes, but
Yeah.
there were some preliminary issues. Kindly, maybe because of oversight. There was a lot of that happened within that period. Yes, my lady, what we are saying that up to now the suspects are being compelled attendance to this on every Thursday, meaning the advocate has to close our office every Thursday, not to attend to clients, to attend to the DCI. This was a court-sanctioned investigation, which cannot go on indefinitely, Your Honor. My lady, with those sentiments, and we were seeking for if they are already done, and they brought here, they ought to have released the documents. We are seeking for release of the documents belonging to the advocate, our gadgets, and also the motor vehicle and the gadgets of the client of the union. We have also filed a similar application yesterday, which is coming for directions today. My lady, thank you.
Your Honor, permit me to weigh in on that particular issue of attendance. Only 1 minute, Your Honor. These individuals are not out either on police board or bail, or even bail granted by this court. You know, they have consistently been attending to the summons or to the orders to appear before the police officers, and they have not taken any actions.
So was that a court order?
No, it's not a court order.
So
it's an arrangement, it's an internal arrangement, Your Honor. With the DCI offices.
Yeah, so
we,
you can move the court so that it stops if they're done with investigations, and if you are so aggrieved that they are still going and there's no court order. If you're so aggrieved, because I don't know what... Yeah, because we don't know what the arrangements are.
I'm well guided.
Yeah, so if there's a grievances, then it can be properly brought before the court. Kindly.